that is Senator Kimbrell and Lieber. Senator Elliott, the chair of that subcommittee. Senator Adams, I'm sorry. Are we on 235D? Forgive me. I have a missed page here, so tell us about it, Sharon.
Thank you, Mr. Chairman. This bill would separate into different code sections the offenses of prostitution and persons who solicit, induce, entice, or offer money or anything of value for the purpose of engaging in prostitution. The penalties for both offenses under the bill as introduced would increase from a misdemeanor to a felony. The bill would also provide that in the prosecution or adjudication of a person who is charged with prostitution, it would be an affirmative defense that the person charged committed the violation under duress or was coerced into committing the violation as a result of being the victim of trafficking in persons. The bill would further provide that a person who is a minor at the time of a violation of the section regarding prostitution may not be prosecuted to conform to similar provisions in the trafficking statute. Finally, the bill would prohibit a person from sexually grooming another for the purpose of prostitution. That offense would also be punished as a felony. Mr. Chairman, there was a subcommittee amendment. That subcommittee amendment condenses some of the provisions of the bill for ease in reading. The amendment would also delete the term adjudication in 1615-90C because the adjudication refers to juveniles and they cannot be charged under that section. Also, indeed, the may would be charged to shall since juveniles can't be prosecuted under the section. And finally, the amendment takes the offense of prostitution back to a misdemeanor as it is in current law as opposed to a felony as it is under the bill. Mr. Chairman, I believe there's one additional amendment.
All right. Senator Adams, anything? Senator Kimbrell and Walker's amendment, you want to tell us about that?
Yes, sir. Under Senator Kimbrell and Walker's amendment, subsection C in section 1615-90 would provide for immunity from criminal prosecution and civil action for a violation of the prostitution section. So this is only referring to the prostituted person. If that person committed the violation under duress or was coerced into committing the violation as a result of being the victim of trafficking in persons, the person must assert statutory immunity prior to trial, and the proper standard for the circuit court to use in determining that immunity is preponderance of the evidence.
Senator Clymer. Kimbrell, forgive me. Senator from Spartanburg.
Thank you, Mr. Chairman. Appreciate that. Senator Walker and I spoke about this, and I didn't mean to jump ahead of you on that, but Senator Walker and I discussed about this in subcommittee. One of the things we learned through testimony, and we talked about this prior to hearing the testimony, but it became more poignant during the fairly extensive testimony we took. Greater than 80%, that's probably a fairly low number of the people who are forced into prostitution, and I think that's the right term, is forced, are, of course, do so under duress. And ultimately, one of the things we tried to do with overall thrust of 235 was to make sure we go after the people who are the demand for basically sex trafficking and prostitution versus the people who are forced into the trade. And so we wanted to make sure we got it right. And ultimately, when you have 80+% of the people who are forced into this lifestyle, we wanted to provide that they don't have to go stand trial when they're already 18. We talked to one young woman, 18 years of her life were robbed from her in Lexington County. She was forced into this right out of high school, got married, has had a really difficult time being able to engage in a normal life after that in her marriage. And she was prosecuted, even though she had been forced into this lifestyle, had to defend herself, and is still trying to clear her name to this day. So Senator Walker and I decided ultimately these folks are victims and shouldn't have to try to clear their name. So we're trying to provide justice for those that were forced in this lifestyle. And so I agreed to join him on this amendment and get it right on the front end. So that's ultimately why we adopted this amendment together. And so at the appropriate time, Mr. Chairman, I'd move favorable on the amendment.
Senator from Spartanburg covered it all.
I have a question real quick. So let me ask you, how can this be used if somebody has been in that lifestyle their entire life, and then 20 years down the road, are they able to utilize this statute to clear their name of something that they did on their own? Or would they have to prove that somehow they were trafficked?
Mr. Subcommittee Chairman, in this case, no, they'd have to prove that they were coerced into it and it was duress. In the case of the young woman we heard from in the
Right.
subcommittee, unfortunately, she's already been charged with a felony. So, I mean, my office is working with her, as you and I discussed, with Triple P to try to get her pardoned. I mean, she's already been adjudicated. We're having to try to get her pardoned. At this point, we're working on that. This won't help her, unfortunately, but it will help future victims.
Thank you.
Mr. Chair.
All right, Senator Walker.
And now, Senator Adams, this would pretty much function very similarly to the stand your ground defense, where you got to have the immunity hearing pretrial and the preponderance of evidence standard, that applies there. And then the circuit court judge ultimately would have to conclude that this individual has met, that burden of proof.
Mr. Chairman,
Senator Ashfield.
is it the intention that the duress must also be from trafficking, or is it only the coercion that's from the trafficking?
Mr. Chair?
Please.
The person, Senator Massey, you would have to show that you were coerced, into prostitution or into sex trafficking.
That's part of it, but it
Right.
also says under duress. I mean, is
Well,
the fact that you didn't have enough money to pay your bills
Well,
sufficient
under
duress to qualify as a statutory defense?
Well, under duress, or in other words, you've been forced into it, not so much because of financial duress. I mean, the aim of this is to get after those individuals who are the purveyors of sex trafficking, like pimps or what have you. So you may have a pimp or someone who's a purveyor of sex trafficking who by force or what have you, who may compel someone into this lifestyle, whether it's under duress or whether it's coercion.
Well, I would just encourage you to look at that sentence and how it's worded and see if you think that it accomplishes that goal. Because my concern would be that the duress and coercion are separate. It's clear that coerced deals with victims of trafficking. I'm not convinced that duress deals with victims of trafficking.
Mr. Chairman? So to speak to that, with the example of Ms. Pagan, who spoke to our subcommittee, I think I understand what you're asking, but so duress and or coerced. In her particular case, if I remember correctly, and I don't remember word for word what she testified, but she dated, or she thought she was dating, the high school prom king, who was a football star, who then basically got compromising information, including her social security number, information about her family, and then basically told her that if she didn't go on these, quote, dates, that he would release that information, and then began to pimp her out, and then got deeper and deeper into a lifestyle she couldn't get out of. And for 18 years of her life, 5 days a week, she was held out in a hotel room off I-26 in Lexington County. So, I mean, I think duress is beyond just financial in that case. So the reason the language is included in this particular amendment of duress and or coerced, or coerced, is because she was under duress. It wasn't just financial. I mean, she was basically blackmailed into a lifestyle. And 80+% of the people we've been able to look at statistically, nationally, certainly in our state, they don't choose this. It's not just because they can't pay their light bills, because they're forced into it by blackmail. And we're just trying to provide a way that people who have already been victimized and sexually trafficked aren't essentially then going to be prosecuted and go to jail when they finally escape a lifestyle they didn't choose.
Well, and I don't disagree with any of that. I just want to make sure that that the senator from Spartanburg's amendment is not creating an out for every person who's charged with prostitution.
Well, and
because of the wording there.
And again, volunteered here, that duress or coerced mirrors the existing trafficking statutes. Not that because we did it that way before means that it's right, but.
So then it's the staff interpretation that duress applies to the trafficking provision as well?
Mr. Chairman, I can certainly clarify that with a clarification amendment that the duress does apply to the result or as a result of the person being a victim of trafficking in persons.
I don't know if that's the senator's intent. I just, look, I'm all for providing an immunity to the situations that the senator from Richland explained and the example that the senator from Spartanburg explained. But I don't want to do something
Mr.
that
Chairman,
would allow for a defense to every prostitution charge. That would be my only concern. But if we can fix that, or if we're comfortable with the way that it is, then.
Mr. Chairman, if we feel that we need to make clarification for that, that's fine. I mean, it mirrors existing statute. No one's trying, if someone's literally going out knowingly, willfully trying to offer themselves as a prostitute, nobody's trying to offer that person a pass. That's certainly not the intent. Nobody's even contemplating that. But a person who's forced into human trafficking or sex trafficking, we're trying to give that person a chance not to be a victim twice. If we have to make an amendment to the amendment here, if staff attorney believes we need to make that adjustment, I'm supportive. I just want to make sure that a person who's already been victimized for 18 years in the case we heard in testimony isn't victimized twice. So if we need to make that adjustment, I'm supportive of making it.
And if I may, Mr. Chair, I would just say, keep in mind just the last part of that first sentence, which is the victim of trafficking, in persons. These are victims. These aren't folks who willfully engaged now in prostitution. So the focus here is on victims. I think that's pretty important.
But it's still got to be determined by a circuit court judge.
That too, correct. Yes.
So perhaps with the invitation for staff to create that technical but perfecting amendment that may be to both existing law and to this, we will instruct her and request the good hands people to help her. And so with that, let's not do that on the fly today. Let's offer that as an amendment on the floor. And do you want to withdraw and hold your amendment subject to a perfecting amendment, or?
I'll ask unanimous. Well, Senator Walker is actually the primary author of the amendment. So Senator Walker, I guess you all need to make that motion to withdraw the amendment.
And with intent here, of course, that we want to fix it and have it right. So maybe, again, off the fly, on the fly here, let's do that on the floor. So are there any other amendments?
No, sir.
All right, with the understanding that that will be wholeheartedly embraced on the floor. There are no other amendments now, so would there be a motion for a favorable report? Senator Kimbrell, subcommittee report, seconded by Senator Rickenbaugh. Any discussion on this? All right, all in favor say aye. Aye. Any opposition? There being none, all right, that'll be reported out. All right, next item, we